Warahmatullahi Wabarakatuh. Welcome, Professor Bouzenita, Professor Anke Sandra Bouzenita from Sultan Qaboos University in Oman, to the 15th lecture on the Tanah Air, the Malay Maritime Civilization Project. We have the pleasure of having you today, and we also thank Professor Aziz Baghut, the Dean of ISTEC, for making this possible. Prof. Aziz, many months ago, contacted me, emailed me, and asked if we can host. When I look at the title, I said this is very much relevant and very much giving us a different perspective in looking into across the Indian Ocean, and it gave me some idea in terms of how we can understand Malay civilization. There are many ways of understanding a civilization, and one of the ways which we've chosen to understand Malay civilization is to look at it from an oceanic maritime perspective. But I was silent over the last few years in terms of the discourse on the Indian Ocean. We were looking in terms of the archipelagic world, the Kepulauan Melayu, and looking into various arguments and various facets of how we can understand and how we can pursue this discourse on the Malay civilization by looking at the Tanah Air or the maritime as the reservoir, which I would tend to compare with Ibn Khaldun. Ibn Khaldun implies the desert as the reservoir for Arab civilization, not necessarily Islamic civilization, but Arab civilization. And by implication, we can see that we can understand better, the characteristics of civilization in the Malay archipelago. And why we bring this also is because this is to counter cynical perspectives, some cynicisms, and deconstructionist parties who have said that the Malays do not have any civilization. The Malays within the located geographically and politically and historically between two great civilizations, the Indian and the Chinese civilization, Nusantara, Nusa, the islands between the two civilizations. But we need to debunk this idea of the incapability of the peoples. When I say peoples, I don't mean only the Malays, but the peoples inhabiting the Malay archipelago and Malay-speaking peoples, of their incapability of advancing and developing. This is a way that we're approaching. We're looking at the Tanah Air, Malay archipelago, as a sociological and historical reality. And this way, I think that you have inspired another perspective, the Indian Ocean perspective. I know the Indian Ocean perspective is not new. It has been around over the last 3 decades, and there was a period in which the Indian Ocean perspective was popular and discourse all over the world, including Malaysia, maybe 10 or 15 years ago, and many papers were produced. Also, at the same time, if you look at the Malay archipelago, it is in the middle of 2 oceans, the Indian and the Pacific Ocean. And in geopolitical discourses in recent times, they're looking into the Indo-Pacific futures of the world. And fortunately, unfortunately, the Malay archipelago is central to this. It has been central over many centuries. So we're glad that you've come up with this title, Maritime Laws and Possible Influences Across the Indian Ocean, a comparison between chosen Omani Fiqh Encyclopedias and Undang-Undang Laut, Melaka. Incidentally, on another note, a group of academics in ISTEC have written a book on the Hadramis from the Indian Ocean perspective. Inshallah, we hope that it is to be published next year. So again, the Indian Ocean factor is very much paramount in order to understand much of the cultures and even religion, Islam, and even architecture of this part of the world. I would like to introduce Professor Bouzenita. Professor Anke Bouzenita is professor at the Department of Islamic Sciences, Faculty of Education, Sultan Qaboos University in Oman. Born and educated in Germany, she obtained her MA 1995 and PhD in 2001 in Islamic Studies from the University of Bochum, Germany. Professor Bouzenita has been working in Algeria, University El Hajj, Patna, Department of Islamic Sciences, 2002-2004, and the International Islamic University, Malaysia, Department of Fiqh and Usuluddin, 2004-2013. Oh, that's quite a long duration. Before joining Sultan Qaboos in 2014. I joined ISTEC in 2019. So we have not met.
We haven't met, no.
Yeah. Professor Bouzenita's research interests are Islamic bioethics, history of Islamic law, Islamic education, international relations, and Ibadi studies. This is peculiar to Oman.
Yes.
With regard to the mazhab that they follow. Her most recent research project is on maritime laws in the Omani Fiqh Encyclopedias. Very interesting. And we hope that your lecture will inspire a similar kind of initiative for Malaysia and the Malay Archipelago. What's important here is that discourses on the Malay maritime civilization has been popular in Indonesia among Indonesian scholars. They have been around. I mean, they've written much. There's a corpus over the few decades, and they're very active in developing Indonesia as a maritime state. In Malaysia, it's quite sporadic, and this is a small contribution from ISTEC. Welcome, Prof. Khalid. A small contribution from ISTEC at using this perspective to frame or theorize Malay civilization. Also, what is important here is not to look into history and civilization from a state-centric perspective. I think history of the world, and especially history of the Malay Archipelago, has been written and has been conceived from a state perspective, and looking at it from state perspectives has disadvantaged our understanding of each other and our understanding of the region, the collective history, the collective memory, the collective geography, the collective spirit. And what we have here so far is that much of what has been discussed in Indonesia looks at it from the Indonesian state perspective. Hence, intellectually they marginalize Malaysia. Culturally, also they do that. So we don't want this to happen. And I think that what we're doing in this tech is to look into across nation state. We have also invited speakers from Indonesia. We have 3 speakers from Indonesia, and we have 1 speaker from the Philippines to develop this discourse. Hopefully, it will end up, inshallah, as a book. Before I hand this to Professor Bouzenita, I'd like to briefly cite synopsis. The lecture will give an insight into maritime rules practiced in the Indian Ocean from the first centuries of the Hijrah to the advent of the Portuguese, attempting to connect the dots between the Arabian Peninsula, represented by Oman, and the Malaysian archipelago. With that, I pass the floor to Professor Bouzenita. Over to you, Prof.
Thank you so much. So, أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على سيدنا محمد وعلى آله وصحبه أجمعين. So, first of all, Assalamu alaikum to everybody. Thank you very much for inviting me. So, I'm grateful to ISTEC to allow me to have this lecture as part of the Tanah Air Lecture series. I hope there will be a benefit for you, for the listeners in this lecture. I should also mention that maritime laws and maritime laws, particularly in the Omani Fiqh Encyclopedias, this is a topic that has been keeping me occupied for quite some time now. So we have in Sultan Qaboos University in our department, we have a research project. So I'm also grateful for my colleagues at the department for discussing a lot of the aspects related to maritime laws in these encyclopedias, and also introducing me to these encyclopedias, because of course when I started working in SQU, honestly I did not have a clue. So I hope I'm a little bit further now. We will see. All right. I should also mention that maybe, trying to connect the dots between the Omani Fiqh Encyclopedias and Undang-Undang Laut Melaka, that is the Omani side and the Malaysian archipelago side, maybe due to my background of having worked in both Malaysia and in Oman for quite some time. So I will try to get started now. Okay. Bismillahirrahmanirrahim. So you have already given the synopsis of this talk. What I'm trying to do is I'm trying to connect the dots, as was already mentioned, between the Arabian Peninsula, here represented by Oman, and between the Malaysian archipelago. So I will talk a little bit about the Indian Ocean trade, because this is the major network that led to the dissemination of Islam and Islamic concepts, and in how far these relations may have influenced maritime legal rules. So we will introduce the port of Sohar on the Omani side and the ports of both Melaka and Kalahbar on the Malaysian sides, because those are two of the most important, or three of the most important ports in these trade relations.
What do you mean by, where is Kalahbar? Is it Kedah?
We are going to discuss this, Prof.
Okay.
We're going to discuss this.
Yeah.
And then we will go into some features of the Omani Fiqh sources, into the features of Undang-Undang Melaka and Undang-Undang Laut Melaka. That is the land applied on the territory, on the ground, as well as the land applied on the sea. And I will try to give some chosen case studies for comparison. Among them are cases related to taxation, the institution of the sea captain or nakhoda, cases of jettison, castaways, and collision. All of them very important topics in maritime law. Now, of course, the Indian Ocean is a vast geographical space, and it has been said that the Indian Ocean world is considered the birthplace of the first global economy. So suffice it to say that navigation already started thousands of years back. And upon the advent of Islam, of course, Muslim merchant networks were instrumental in the dissemination of Islam. The trade networks were already there, but then Islam came into play and unified the littoral of the Indian Ocean coastline in that sense, to a large degree. So within less than a century after the beginning of the Islamic call in Mecca, Muslims had already dominated more than half of the maritime world, which is quite a lot. The Indian Ocean trade routes are historically well established. So there are a lot of reports, both in Arabic sources, as well as in Persian sources, as well as in Chinese and other sources, probably also in Indian, probably also in Malaysian, but I have not researched in those yet. So, for example, we have the 9th century travelers Ibn Khudadbi in his Kitab al-Masalik wal-Mamalik. We have Sirafi in his Akhbar al-Sini wal-Hind. And they actually describe the trade routes from Siraf, which is today's Iran, Persia, and Sohar in Oman to Guangzhou, to Canton in China. And what they mention here has been reconstructed as a travel route by Hurani, who said that, well, the route from Muscat to Kolam Mali in South India probably took 4 weeks, a month, then to Kalahbar, probably more than Kedah in Malaysia, but we're going to talk about that. Then to San Fulao, which is an island, off the coast of contemporary Vietnam, and then to Canton. So every step would take 1 month, which means that you would have a total of 120 days sailing time, only sailing time. But then, of course, consider the stops in between. So you would have about a travel of 6 months one way from the Arabian Peninsula to Canton. And then usually, of course, the whole thing is bound by the monsoon winds. So they would set off from Arabia in, well, second half of November, maybe beginning of December. And the return from Canton would then be after spending the summer in Canton. So returning to Muscat in May the next year, which means that it's a 1-year travel going back, going to and back. Now, in the beginning, obviously, some ships for quite a while, they made the entire route from the Arabian Peninsula to China, to Canton, via the Malaysian archipelago and back. And then at a certain point in time, it seemed to be more practical to just do it half route. That is, stop in Malaysia, that is the Malaysian archipelago, and leave the cargo there, and then have it stored there and have it sold to the other, you know, the merchants who would come from China to the Malaysian archipelago, and trade would take place in this way. So here we have a nice map. Not going to go into the details because we don't have time, but in here it does mention Sohar, it does show Sohar, it shows Kolam Mali, it shows Kalahbar or Kalah, and it also shows the other steps. So that's another, sorry, I just opened it by mistake, another map showing the same thing. Now, what I'm most interested in, of course, is the legal matter, the maritime law, because my background is an Islamic law background. And very often you would find statements like, you know, the maritime regulations and practices, they are shrouded in obscurity. We don't really know how they started. We don't know how modern international maritime law started. Actually, it is not too difficult to find out. If we go back in history a little bit, there is a lot of research on maritime law in the Mediterranean, but for the Indian Ocean, it has only just started. So what I will try to do here is present some of the rules and regulations of different eras, different regions. That is 2nd to 9th century Sohar in Oman, as described in the Fiqh Encyclopedias, and the 9th century Melaka, as described in the UUM and UULM. Sorry, I'm giving the abbreviation now for Undang-Undang Melaka and Undang-Undang Laut Melaka because it is so long. So now let us look at the port of Sohar, first of all. Now, just to give you a little bit of background, the people of Oman, of course, had already accepted Islam in the lifetime of the Prophet. And Sohar was the most important, alayhi salatu wasalam, and Sohar was the most important town, the most important port town. It was the capital of the Imamate from the 2nd century onwards. And there were very prominent scholarly figures who were also involved, of course, in state authority, such as Imam As-Salt, his chief judge, Muhammad ibn Mahbub. And the guidelines that they had laid down, that have been narrated, transmitted from them, they are passed on for the next centuries to come in the fiqh compilations. So you will see that these people, they were not scholars who would, sit in their little places and not go out. Those were people who were actually involved in the subject matter on the ground. So Sohar was also important in the spreading of Islam across the Indian Ocean. And as I said, I focused on the Omani Fiqh encyclopedias. Of course, you need to mention the Ibadi school here, because those Fiqh encyclopedias are encyclopedias of the Ibadi school. The Ibadi school was established by the Tabi'i, that is the second generation after the Prophet, after the Sahaba, Jabir ibn Zayd. And he is the scholar who is responsible for the legal subject matter of the school, while and its foundation, while the school itself has been named after Abdullah ibn Ibad, Ibadi school, Ibad. Now, Abdullah ibn Ibad was a spokesperson of the movement at the time, and this is why the movement has been given this name. And the name obviously has been continuously used. Now, the Omani Fiqh encyclopedias, of course, there are very, very many of them. So I try to focus only on some chosen encyclopedias, just to give you an idea that the oldest encyclopedias that are available, even in print today, are the encyclopedias of Jami al-Fadl, Jami Abil Hawari, and Jami al-Izkawi. And I'm now skipping a lot of names, and I'm just mentioning other scholarly figures such as Abu Sa'id al-Khudami. You have the centuries here written next to them, to al-Kindi and his Bayan al-Shara, to his namesake al-Kindi and his Musannaf, to al-Shakhsi and the Minhaj al-Talibin, to al-Sa'adi and the Qaboos al-Sharia, which may be the last in chronological order. Now, the particularity of these Fiqh encyclopedias is that, first of all, they seem to give focus on cases that have not been mentioned or hardly mentioned, elaborated on in the Fiqh compilations of other schools, like the law of the sea. So you will find entries in these encyclopedias that you will hardly find in other encyclopedias or compilations of other schools. I have, for example, done research on Harim al-Bahr, which I could find in these encyclopedias. I couldn't find it elsewhere. So obviously, the scholars were very much involved with the sea, given that Oman has a very long coastline. And the sea has a very important part, is a very important part of the history and legacy of the place. And the merchant routes were well established, as we said. Now, there were a lot of legal cases that needed to be solved. So just to let you know that even though Sohar was the most important port for maybe 6 centuries to come, and there were political factors that changed, and there were trade routes that changed and ports that changed, but still the legal subject matter, more as you can find it in the encyclopedias, is more or less the same. So this led me to suggest that whatever was implemented on the ground did not change very much. So in other words, at the time, the Sultanate of Melaka was established, as the history books say, by the fugitive prince Parameswara at the end of the 14th century. And by the time both Undang-Undang Melaka and Undang-Undang Laut Melaka were compiled, the legal concepts as reflected in the Fiqh compilations were pretty consistently the same. Now, for the Malaysian side, or the Malaysian or Malay archipelago side, maybe we should say, we may not have documented evidence in the form of legal digests or codifications prior to the Sultanate of Melaka, but the intense Indian Ocean trade and the spreading of Islam in the region indicates that there must have been legal rules that were implemented. And in here, of course, given that this region of the Islamic world very soon adhered to the Shafi'i school, then the Shafi'i school must have played a role here. Now, the Sultanate of Malacca and its port, talking about the conversion of Southeast and South Asia to Islam. Of course, it was a complex issue. It was a protracted process, as they say. And maybe it was accelerated by political conversions. What they mean by political conversions, of course, is that when the head of state or the Sultan becomes Muslim, his people will become Muslim with him. And this is what happened in the case of Malacca. Now, the port of Malacca was particularly important with the inception of the Sultanate of Malacca, and it became the most important trade center and transshipment point, that is an entrepot, in the trade between China and the Middle East. And in the 15th century, just to give you, one glimpse, there were some 15,000 merchants of different nationalities. There were Chinese people, Arabs, Persians, Indians, and more. And Malacca, again, also became a regional center for the propagation of Islam. Okay, so Malacca is referred to as an entrepot, as a commercial place in between other places. I have already mentioned this. And the Sultanate of Malacca had dependencies across the states, which may give us a clue as to the legal, concepts and the legal rules that have been implemented. Now, upon the arrival of the Portuguese, Malacca alone had some 190,000 inhabitants, which is a very, very large number for the time. Among them, 61, they say, different communities with 84 different languages. That's amazing. Now, with regard to maritime trade, of course, we need to mention some of the functions. There was the function of the Shah Bandar. The Shah Bandar, if you want to find the position that compares to it in Oman, it would be the Sahib al-Sahil. Malacca knew the institution of 4 Shah Bandars, reflecting the volume and importance of trading at the time. So every ethnic group had their own Shah Bandar. And the Hukum Kanun Malacca mentions that the authority given to the Shah Bandars is to look after foreigners, orphans, the oppressed, as well as regulations regarding seagoing crafts and vessels. We have descriptions in the Suma Oriental of Tome Pires, who was a 16th century Portuguese traveler. So a lot of information can be taken from here. And the Shah Bandar, by the way, was the only position probably that was open for foreigners, for non-Malays, for good reason, because they were in charge of these different ethnic communities. I could not find a particular Shah Bandar for an Arab or Persian community, but, well, maybe it's just missing in the sources. Now, the first question I asked myself was, do the Ibari Fiqh Encyclopedias actually mention Malacca? Do they mention the Malaysian archipelago? Do they mention anything that alludes to the trade there? And here, interestingly, they do not explicitly mention the Malaysian archipelago, but there are some names that turn up that give us clues. Names of places, usually they refer to Sarnadip, which is today's Sri Lanka, which is also part of the Indian Ocean trade route. But they do mention, even in the 3rd century encyclopedias, that is 3rd century after Hijrah, 9th century AD, they mention Chinese and Kalhiya boats. Chinese is obvious, but Kalhiya, I spent a lot of time trying to find out what do they mean by Kalhiya boats. And then, of course, I came across Kalahbar. Kalahbar, there's a lot of discussion among the scholars, contemporary scholars, where was Kalahbar? So let us say that it was probably in today's Kedah, that is on their coastline. And Kalahbar was the main trading point for Arabs and Persians before the rise of Malacca. And again, if we say that we have a codification of legal rules for Malacca, it does not mean that before that there was nothing. Before that there must have been something, because the trade point, Kalahbar, was already frequented by all these communities, from the Arab Persian side as well as from the Chinese side, and they must have had rules and regulations. So in other words, precursors to Melaka and to its codified rules may have existed. And by the way, to whoever is listening in now, if anybody has more information than I could gather from my sources, I'd be really, really grateful for any hint concerning this. Now, Undang-Undang Melaka, Undang-Undang Laut Melaka, and the role of customary law. Now, the Hukum Kanun Melaka or Undang-Undang Melaka, of course, was the law applied on land, while UULM, Undang-Undang Laut Melaka, was the law applied on the sea, concerning matters regarding navigation, responsibilities of captain and crew, matters of the jurisdiction of the Nakhoda, of the sea captain. And both sets of rules actually are characterized by a majority of Islamic rules based on the Shafi'i madhab. And there is mention of some customary laws. And I would like to just seize the opportunity and talk a little bit about the role of customary laws, because when I did my research for this talk and for this paper, I realized that there seems to be a little bit of an overstatement on the role of customary law. So I just skipped a couple of slides. I will come back to them, inshallah. So some of the contemporary scholars on Indian Ocean trade networks, the laws that have been, the maritime laws that have been applied there, they seem to think that, well, based on the interaction of different communities along the littoral, they seem to think that the law applied must have been some kind of hybrid. They seem to think that, well, all those Muslims who were engaged in trade there with each other and with other people, they cannot have applied Islamic law. And unfortunately, they do not produce hardcore evidence. I would like to see hardcore evidence for this, and I couldn't find it. Okay, so my idea is that sometimes maybe contemporary authors misunderstand, if that's the right expression, misunderstand the nature of Islamic law. It is in the nature of Islamic law to have different sets of legal rules. You have the clear-cut, qat'i rules. You have the dhanni rules that are open to ijtihad. There is plenty of room for difference of opinion in that second category based on the evidences. And of course, custom or urf may have played a role, because it is considered where there is no contradiction to Islamic legal rule or a text. But this is part and parcel of Islamic law and the process of finding rules. Now, very often I found circular arguments here that do not really help us to understand which legal rules were actually there on the ground. Well, coming back to our legal rules now. The Undang-Undang Laut Melaka, the Melakan maritime law, is considered to be the earliest manuscript in the Malaysian archipelago. It does not mean that it is the earliest one that ever came about. It does not mean that there have not been different or other codifications before this, but we know that it was disseminated, and it became a very important basis for different regions and different sultanates even in the region to adopt. We also need to look at the Arabic and Persian terminology in both of these legal rules, or sets of legal rules in both of these codifications. Terms like Nakhoda, of course, Nakhoda is a Persian term. It is used in the Omani Fiqh Encyclopedias as well, interestingly, starting from the 6th century. And there are Arabic terms, of course, given that Arabic influenced Malay at the time, the people having become Muslim. And these sets of rules were then passed down. Now, again, the Melaka Code was probably not the only existing and not the earliest code at the time. Okay, in some instances, sorry, I have not finished this train of thought here. In some instances also, you know, there are in the Undang-Undang Melaka, for example, they mention a ta'zir punishment, which is part and parcel of Islamic law. Now, when you look at this punishment, you will say, oh, where did they get that from? That doesn't have any relation to any text. But actually, ta'zir comes into practice wherever the conditions for a had punishment are not met. So it is part and parcel of Islamic law, and it is up to the judge or up to the ruler to define what kind of ta'zir punishment is appropriate. So in the Undang-Undang Melaka, for example, there is one statement of a ta'zir punishment which I found quite interesting. And they even mention the term ta'zir here with regard to people who are complicit in theft, but they do not qualify for had, for the Islamic legal rule and its implementation. So in this case, the offender will be placed on a white spotted cow adorned with hibiscus flowers and a dish cover over his head. His face will be smeared with lime, charcoal, and turmeric, and thus will be carried around the country while a gong is being beaten. So in other words, just publicly shame them with all the available means that you have. So if, of course, you do not know what the nature of Islamic law is, and you look at these points, then maybe you are inclined to say, they just made use of anything, but it is actually ta'zir as ta'zir. It comes under Islamic law as a framework. Now, we also have evidence, of course, that Muslim, mainly Arab and Persian settlements were established along the Indian Ocean littoral, and that those saw the practice of Islamic law because, well, historical evidence is there. We know that even in Canton, in Gwangju, a Qadi, that is a Muslim judge, was appointed to judge among the people in the settlement of their disputes. Sirafi describes this, as we said, 9th century. And, well, again, you cannot analyze, from what I understand, the Undang-Undang Laut Melaka without going back to the Undang-Undang Melaka, because the first Undang-Undang Melaka is like the groundwork, the foundation for the second. And the second has been codified as an addition because obviously some of the sea captains found the Undang-Undang Melaka not sufficient for cases that related to the sea. And this, by the way, is also the origin of the Undang-Undang Laut Melaka, where a number of sea captains, and they are named in the manuscript, sat together and discussed these laws and then had them signed off by the Sultan. Okay, so both refer to Islamic law and Adat law, but as different legal bodies. So where there is a clear distinction to be made. So these Adat laws are not part and parcel of Islamic law, and they can't be. They say it. They say that this is the Islamic rule, but this is the Adat rule. And sometimes they are juxtaposed, that is, put next to each other, as in the crimes of trespassing or rape. Both the Islamic punishment and the Adat punishment are mentioned. And the text often clarifies that the law of Allah is different, thereby distinguishing between Adat and Islamic law. So what remains to ask, of course, is why do we find these Adat laws? Why have they been important at the time? And here, well, I'm conjecturing now, and going back to some of the suggestions that I found in the literature. So it is possible that at the time there were different pro-Islamic and pro-customary forces at work when the Sultanate of Melaka was established and when the codification came about. So there may be these reasons. It may also be that they destined these rules for different sets of people. It is one of them being destined for the Muslim population, the other one for non-Muslim population. But it is not really clear, and I think more research needs to be carried out here. anyways, so these are some of the maritime rules that I could find in the Undang-Undang Melaka. That is the non-specialized maritime law, but still there are a lot of rules related to maritime law here. For reasons of time constrictions, we're not going to go into the details, but I hope that you will be able to read this up, inshallah, in the book chapter later. Interestingly, there is a lot in the Undang-Undang Laut Melaka on discipline on board a ship, the organizational structure, you know, which are the positions, and it looks like they mentioned these positions in analogy to the positions available on land, in the government on land. And when it comes to the muallim or navigator, muallim, of course, also being an Arabic term here, it says that the navigator should not fail to pray to Allah and his prophet, for he is an imam on board a ship. So it was like they could not find a different position as compares to the positions on land. So they gave the muallim or navigator the position of the imam on board a ship, because he's the one who navigates. Quite interesting. So what I will try to do now is I will you know, single out some of the legal cases and compare them between the Fiqh Encyclopedias, the Omani Fiqh Encyclopedias, and between the Undang-Undang Laut Melaka. Okay, so these include the position of the sea captain, taxation is here, the position of the sea captain, changing the route or destination, jettison, castaways, and collision. All of them, of course, very important issues in maritime trade. Now, for the taxation procedure, in the legal codifications themselves, I could not find very much on taxation procedures for the Malay side. But we do know from the Summa Oriental, that is Tommy Pierce's travelogue, that foreign traders, they needed to ask for permission from the Shah Bandar, to see the Bendahara, to seek his permission for trade, and then the Shah Bandar would send elephants to get the cargo out of the ship, and then trade could begin after duties had been paid. Duties being of two kinds. That is, there was a fixed duty for traders from India, Sri Lanka, Arabia. They had to pay 6% of the merchandise's value, and traders from China and Japan had to pay 5%. And then in addition, they needed to pay or they needed to give presents to the people in charge. And this is also fixed, obviously. So what I could find in the codification, Undang-Undang Laut Melaka, was only that countries levy taxes on the divisions of the hold, and so it just says that these tolls can be collected, and if there is a war, country at war can levy a toll from merchant vessels, but there is not much detail as to how much, as to, you know, which percentage from whom, and how about issues of, you know, zakats and ushur. Now, zakat, as we all know, is the amount of money that a Muslim pays every year on his or her possessions, with many conditions that apply. We are not going to go into the details. And zakat on the merchandise would have been 2.5% for Muslims. The term ushur relates to taxes that have been levied from non-Muslims. And now all of these are mentioned in a lot of detail with the procedure in our 3rd century encyclopedias, that is 3rd century after Hijrah, 9th century AD. And they are mentioned with a condition. So the condition is always that no taxes of any kind are raised or levied if these tradesmen, merchants, ships have not been protected by the Omani fleet, that is. So there is this very nice statement of the first Imam of Oman, Al-Julanda, Ibn Mas'ud, who sent a question to some of the scholars involved and said, you mentioned that you are taking the zakat of people coming in from the sea, while there is a distance of 3 or 2 days between you and you do not protect them. Be informed that we do not like that you take something from them while you do not protect them. So in other words, taxes are only levied if protection is provided. And this applies to everybody involved. It applies to the Muslims originally residing in Oman. It applies to the Muslims of other regions and other origins. It applies to non-Muslims living under an Islamic government, the Dhimmis, and non-Muslims entering the port as tradesmen. Now, I'm not going to give you all of these details here. This is just a translation of the part I found in Iskawi's book, Jami al-Iskawi. Ibn Jafar al-Iskawi was himself in this position of being the Sahib Sahil. So he knew exactly what he talked about, and he described the procedure and also criticized the procedure for being, not practical enough. So you can read this all, hopefully, inshallah, later. Just to give you a summary of this, in the end, they charged for every 20 dinar, not less than 1 dinar as Osho, that is as a tax from non-Muslim merchants coming from abroad. And that would be, well, 5%. Otherwise, they emphasize the principle of reciprocity, which is that, we take from them what their king or their governor takes from us. So if their king takes 1 dinar out of 2, that is 50%, then we will take the same amount from them. If their king doesn't take anything, then we're not going to charge them at all. For Muslim merchants, it would be the zakat of 2.5%, of course, with conditions. If they hail from Oman, if the year has already passed by, but if they hail from other ports of origin and they're Muslim, then they may deduct zakat in Oman if they like. They may also deduct their zakat in other ports. So this zakat al-bahr, that is the zakat from incoming goods from the sea, is very, very specific in the Omani Fiqh Encyclopedias. And of course, if you compare both, there's a bit of a mismatch because for Melaka, we do not have the entire documentation. So maybe there is something in the fiqh books of the time that I haven't come across. So I try to compare here between, a description from a foreigner and a codification and then a fiqh book. So I am sure that there are many more details for the Melacan side that have not been transmitted in the sources that I consulted. Let us put it like this. Now, away from taxes to the sea captain, the nakhoda. Now, the term nakhoda is most likely Persian. In our books, it's sometimes referred to as nawkhoda. The plural form would be nawakhida. And it is not used in the very early Omani texts on Islamic maritime laws. It starts to get into usage from the 6th century, the 12th century AD, with Kindi's Bayan al-Shara, which may be a clue as to, the growing influences and also maybe growing unification of terminology in that area. And also, of course, the Persian influences that have also always been there. Earlier sources would refer to the sea captain as Sahib al-Safina. And, well, what do you find on Sahib al-Safina, on the nakhoda or nawkhoda? As a technical term, up to date in Oman, the term Sunan al-Nakhoda or Sunan al-Bahr is used for established practices of the sea captain. And even among, seagoing people today, you have this established practice, and it even plays a part in court. So there are institutions who keep this or that keep this tradition alive. So Sundan al-Nakhoda, the established practices of the sea captain, has come to comprise Islamic legal rules as well as general etiquette on board a ship. And it remains today mainly on oral, it relies mainly on oral transmission, is still considered in contemporary maritime law. Now, we find that the early treatises, okay, sorry, no, I've already mentioned this. Sorry. Now, what we may find as the earliest sources of Sunan al-Nakhoda or Sunan al-Bahar actually is a manuscript that quotes some of the dicta of Abu Sa'id al-Khudami, who was an Omani scholar. So this, what is coming now, I did not find in a book. I found it in a manuscript that has recently been published, edited and published by Dr. Abdurrahman al-Salimi. And in here, we find detailed provisions regarding etiquette on board a ship, sitting arrangements, using water for ablution, putting laundry on the decks, explicitly mentioning that these are customary. And by the way, a lot of these details we will find in Undang-Undang Laut Melaka as well. Where can you sit on board a ship? What can you do? Do you need the permission of the captain to use the water? It has also other cases like liability for damage to items on board, buying and selling on board, liability for jettisoned loads, praying on board the ship, washing the dead, the powers of the vessel's captain. It's quite comprehensive. In both the Undang-Undang Melaka and Undang-Undang Laut Melaka, nakhodas or sea captains are referred to as an important social group with functions of their own. And as we have mentioned before, the compilation of the Undang-Undang Laut Melaka itself is led back to the initiative of a group of those nakhodas. So it shows you just how important they have been. Now, a very important statement in the Undang-Undang Laut Melaka is the captain or nakhoda is a king on board his ship. He rules, he has authority. And he was given authority to implement capital punishment for zina, which is quite something. So he was not only the sea captain, he was also a judge, obviously. So the Undang-Undang Melaka already stated that the law at sea is the responsible of the sea captain. And here, the responsibility or the authority to implement capital punishment is given to him only in case of zina, of adultery. And we have a lot of other stipulations here in the Undang-Undang Laut Melaka, Undang-Undang Melaka, sorry, where it says if the sea captain avoids custom duties and returns to the country, he will either have his goods confiscated or fined twice the customs duties. And this is an uncivilized behavior. So nakhodas were quite important, and they were given a lot of importance. Now let us look at another topic here, another case, which is a sea captain allowed to change the route? Can he just, take another route than the one that has been agreed on? And what if there's a delay in the time schedule? So the Malaysian Malaccan maritime law states that the nakhoda had to confer with his crew if he wanted to stop at any port not on the original schedule. And another clause states that if a ship is more than 7 days late in sailing and then misses the monsoon through the tardiness of the captain, the latter has to refund the price of his division in the hold of the supercargo. If a ship risks missing the monsoon because the supercargo has not come on board, the captain is entitled to sail off after waiting 7 days, and so on. And then this very, very interesting statement, a ship rigged and ready to sail is like a king about to leave his palace. Don't stop the king, don't stop the ship. And then, of course, if you bear in mind that once the monsoon is gone, then they would have to wait for another year. So this is quite an important topic that needs to be regulated. And in the appendix, it says that a skipper who takes a passenger with cargo to a different port than what is agreed on is responsible for his actions. However, he need not pay more than double compensation. But then double compensation is quite a lot if you come to think about it, right? Now, if you look at the dictum of our Omani scholar, Abu Sa'id al-Qudami, regarding the same issue, changing the route. So he was asked, may the sea captain, Sahib al-Safina, anchor down at one of the coastlines that is not on the route of the passengers for their livelihoods and trades. If the passengers refuse this and demand to abide by the agreed route, is he asked to return to the agreed route? He said yes. If changing the route harms them and prevents them from fulfilling their needs, he can only do this if he previously imposed it as a condition on them. And then we have similar statements in another early Fiqh encyclopedia, you know, talking, giving one example here, somebody who was hired to transport somebody from Basra to Sarnadip to Sri Lanka. And then they reach until Oman from Basra. And then the client changes his mind. So this is not about the sea captain changing his mind. This is about the client changing his mind. And he wants, now suddenly he says he's never been to Sri Lanka before and he doesn't know it. He doesn't want to go there and he wants his goods back out of the ship. And the question now is, what if, you know, the sea captain now or the owner says that these goods are at the very, very bottom of the ship and I cannot unload them because I will be delayed if I unload them. So in that case, what do you do? The answer is if the experts agree that there's harm to the passengers of the ship. So first of all, you have expert opinion here is important, right? Then the requester who wants to stay may stay in Oman while his goods remain on board the ship. So let the owner stay, let the goods travel because you cannot delay everybody else. And then somebody who is authorized may take or receive these goods when they arrive in Sarnadip in Sri Lanka. Very, very detailed legal rules here. And it goes on and on. So I'm going to skip this part because it is quite similar. And let us move on to jettison. Now, jettison, of course, means that if a loaded ship runs danger of sinking because the weather is bad, and there is a danger for the lives of crew and passengers on board the ship, then the load is partially or fully unloaded so that the ship becomes lighter and more maneuverable and possibly people on board are being saved. This is the meaning of jettison. Now, is jettison permissible? And if so, which rules and conditions apply? The Undang-Undang Laut Melaka says before throwing cargo overboard in a storm, the crew has to be consulted. Because, of course, in the Malaysian codifications, we need to understand that the crew also always had parts or a right on part of the cargo. So they traded themselves. So part of the cargo belonged to them. This is why the crew needed to be consulted, because they were partly owners of this cargo. So it says here, if they also share in the cargo, they need to be asked. In that case, the part of each crew member's share in the cargo that is to be thrown overboard should be proportionate to the size of that share. So if one of them, let's say, owns 5% and one of them 20%, you cannot throw the entire 5% of one person out. No, you need to throw 1% of the one who owns 5% and 1% who, or more like that, in proportion, that is, of the one who owns 20%. So let us say for the one, you throw 1%, and for the other one, 5%. So it needs to be in proportion. And the dicta of Al-Qudami, again, the Omani scholarly authority, in the manuscript I just mentioned, he says it is permissible for the passengers to throw the load overboard if they fear for their lives. And then there is a big discussion on the liability. So who is liable for this? The liability, who needs to pay for this in the end, is on all passengers, because the load is jettisoned for the safety of all. So everybody needs to be held liable. Then there is a case where if the storm hits them in the ocean and the merchants jettison their merchandise, the mudarib here is somebody who has a share in a business with somebody, has to jettison the goods in relation again. So if he has goods of different people who invested in him, he needs to throw them over in relation if the safety of lives lies in throwing them overboard. He is not liable to the owner of the capital, Wallahu alam. And it is also said he is liable. So there's a difference of opinion here. If the owner of the merchandise jettisons the goods without agreement between them and him, and they are saved, they are liable to him according to the number of individuals that have been saved, and so on and so forth. So we have a lot of detail on these questions. There are cases where, you see, maybe somebody finds jettisoned goods, and he said, maybe the owner later says, if you retrieve this for me, I will give you a share in it. How to deal with this? What happens if a ship owner transports goods that resemble each other? So let us say there are 10 people who have cargo on a ship, and it is all dates, or all, comparable goods, and you cannot keep them apart once the labeling is gone. In a storm, of course, the labeling would be gone. And then it is thrown over into the sea, and in the end, you do not know which one has been thrown out, which one is still there. So what's the procedure? And in here, they make a very nice comparison to, when the harvest of seeds on land gets mixed up by a storm, then, and the supervisor does not know which grain belongs to whom, then he would just distribute according to equal shares among the people who lost their seeds. And if they can't agree on something, the owners, because, there's a dispute, this one says this is mine and the other one says, no, this is mine, then it needs to be distributed among the poor. As simple as that. Okay, so we have more cases here in another book, in Kindis Bayan al-Shara, which is from the 6th century. And in here, very refined on liability. If the Nakhoda fears shipwreck and jettison the cargo according to his opinion, there's a difference of opinion with regard to the liability, the man. One opinion is that if he jettisoned the cargo out of fear for the ship, he may do so as to save the people on board with the possessions, and the liability for the jettisoned goods is upon all passengers. Another opinion is that there's no liability on the passengers, but specifically on him, because he transported them by contract. If the navigator jettisoned the cargo according to his view, then liability is upon him. Yes, and so on. Now, I think this may be the last but one case. Castaways, people who, as a result of shipwreck, end up somewhere. They may end up in the sea. They may end up somewhere on a deserted island. They may end up in enemy country. They may end up anywhere. So how about dealing with these people? The Undang-Undang Laut Melaka has procedures for the Nakhoda who met castaways with their treasures due to a shipwreck. So let's say he's en route and he finds a ship that has been wrecked, and there are people who are just clinging on to the wreck for good life. Who rescues shipwrecked mariners can claim 1/2 a ta'il, which is an old Malay measurement, head from the boat's twain. And so this is the procedure. And also it says in the Undang-Undang Melaka that a shipwrecked person must not be enslaved. So there's a whole case on that. Let us say you find somebody as a captain who has suffered shipwreck, and he just clings on to good life and begs you to take him and tells you that, you know, just take me, you can sell me as a slave later, which of course may have been a common procedure in those days. And then the codification here says he must not be enslaved, even if he agreed to this condition to save his life. The rescued person has to pay half of his value upon intervention of the Shahbandar, as it is customary not to heed the words of a shipwrecked person when he says he is willing to be sold as a slave, because such words are uttered at a time of distress, which is an Islamic concept, by the way, the distress ikrah. If you are in a position of distress and you promise something, say something, it is not considered in contracts. So if the Bayan al-Shara here, okay, sorry, the Bayan al-Shara here has even more, you know, cases and branches of cases to discuss. What if, for example, somebody suffered shipwreck and with him is an orphan? The orphan has provisions, but there are also provisions in the wrecked ship. So which one is preferable to take? And the ruling here is that it is better to take whatever has been found on the ship, because it is better to make use of this lost good, which is considered to be a lakta, it's a lost good, than to eat in that sense, or consume the belongings of an orphan, which are protected by Islamic law. And then also a very interesting case here, a person who suffered shipwreck may hold fast to whatever he can, that is, whatever floats, the flotsam, until he reaches the coast and is rescued. And he needs to guarantee for it, that is, pay any damage later. I found one explanation to the same case, also in reference to the same book, but in Qaboos al-Sharia, As-Sa'di's Qaboos al-Sharia, that may, you know, make us understand the case a little bit more. So let us say a group of people suffer shipwreck at sea, and a ship passes by, and the passengers dislike to let them get on board. So they cling fast to the ship until they drown. Quite dramatic. We see that they are liable, because that is, the passengers are liable as they committed a crime. It is a crime to just let people drown when you have the possibility to rescue them. So they are liable. They have to pay the diya for them, the blood money for them. Unless, okay, now we have a little bit of a specification, unless they had rented the vessel for transport. So in other words, they are passengers, but they are not in command. They cannot take decisions. They are not in authority, and the ship owners do not want to transport those shipwrecked poor people. In that case, the passengers are not liable, but the ship owner is. So it is quite refined. Okay, I think this is our last case, the collision. Ships colliding at sea, which may have happened, well, quite frequently, you know, just like today, maybe cars collide on land. Ships may have collided on sea. Who's responsible? The Undang-Undang Laut Melaka says, in case of a collision between two vessels sailing in convoy, that is one behind the other, leading to one vessel being wrecked, the master of that vessel should lodge a complaint before a judge. The master of the vessel that caused the collision must indemnify 2/3 of the other vessel's loss. This applies if the collision took place at night or during a storm. If it took place in daytime, the total loss should be refunded. And then in Bayan al-Shara, we have so Al-Kindi's book, 6th century, 12th century AD. if a manned ship collides with and breaks an immobile, unmanned ship, it is responsible and needs to cover the damage. If both ships are unmanned, none of them is liable for the damage. So let's say they were just rogue ships, you know, getting loose, then nobody is liable for the damage. If the following collides with and breaks the preceding ship, the following ship is responsible. That is, they are in convoy. The one that is behind breaks the one that is in front. So the one that is behind is responsible. The preceding ship is not liable for the damage of the following, should there be any. Should they collide coming towards each other, so that is, they're facing, colliding, coming towards each other, they are both liable. You know, these stipulations, they read like very modern regulations you would find in insurance companies, you know, rules and regulations. So if you hit the car that is in front of you, you are liable, and so on and so forth. So I have tried to give you, you know, an idea on what we can find of legal subject matter regarding maritime law in both the Undang-Undang Melaka, Undang-Undang Laut Melaka, and in some chosen Omani Fiqh encyclopedias. And let me say that, of course, I compare different eras in different places. But maybe you have observed that this all sounds so familiar. First of all, so very familiar to what we know today, and also so very familiar in comparison. So there must have been a common source to both of these different sets of compilations. And just to, you know, remind you, in the beginning I showed you a map of the Indian Ocean. So I only took out 2 dots to connect. I only talked about Oman, Sohar, and the other parts of Oman, of course, that played a role, like made later on Muscat and Kalhat and Al-Balid in Dhofar, probably, and Melaka and Kalahbar. So we connected the dots between those 2. But all along the way, we had comparable stations, right? We had the station in what was it, Kulam Mali. We had the station off the coast of Vietnam. We had the station in Canton. We have other stations on different lines of the Indian Ocean trade route to Africa, to India, and the procedures must have been very similar. So I did not delve into the sources. Because at some point you need to confine yourself to what you know and what is available. But I am quite confident that if more research is carried out in the earliest sources we can lay our hands on, we will find that these rules and regulations are very similar, and they, in the end, are going back to Islamic law. So while maritime law has been officially codified in 15th century Malacca in both these legal codifications, the Islamic legal rules regarding maritime trade, transport, legal disputes are pervasive in the Omani Fiqh Encyclopedias, and they can be dated back to the 2nd, maybe even the 1st century of the Hijrah. So the personal involvement of scholars in administrative functions does not leave a doubt as to its implementation. So you can actually follow up the names that have been mentioned in these fiqh encyclopedias, the scholarly authorities. And when you research them, you will find that this person has been in charge with the port of Sohar. This person has been in charge with protecting the fleet, and so on and so forth. So you know that they were not just looking at it from a theoretical point of view. They were practically involved. So, as I said, I try to identify 2 important dots across the Indian Ocean that can, even over the spatial and chronological distance, be connected. And the similarities, I think, are quite obvious for the legal cases at hand. And I would really wish for, more researchers to delve into this topic. It is really, really interesting. I hope you found it at least partly interesting, and my listeners have had some kind of benefit from this discussion. So my last words will be just thank you very much for staying with me for this 1 hour and even more than 1 hour. Alhamdulillah Rabbil Alameen. So I have my references here, of course, and I hope to be able to share, you know, the entire thing here as a book chapter with you.
Yes.
Inshallah.
Thank you very much, Professor Bouzenita. This is a very pertinent disclosure. One with regard to the comparison between the Omani Fiqh and the what we call Undang-Undang Kanun Melaka. And one of the things which struck me is the Qadah Kanun, and Qadah also has a long experience with maritime, with the seaport, Kota Kuala Kedah, Kota Kuala Bahang. They have been practicing, and I was reading the history of Malaysian legal history. And the point of contention is that there's a lacuna in this discourse with regard to what law, what was the locus lex loci of in Penang. I have to refer to that. Yeah, between 1786 and when the Charter of Justice was introduced on the island in 1805. There are many sources, but what those sources say is that it resonates the maritime laws. It resonates the Kalah Bar or Undang-Undang Kedah as such, and this was argued by Ahmad Ibrahim, the professor of law in the IIUM. He said that it was not British law, but it was the customary law modified by Islamic law that was used in the context as a lex loci in the island of Penang, in terms of also its the context of the maritime. So that's one aspect that you have given me. The other is I see. I'm not an expert, and I'm not a historian or expert in maritime law. Professor Khalid may give another perspective on this or another question, but I see a different narrative. The Omani Fiqh joined was placed within actual geographies. It named places. Whereas the law in Melaka and Kedah is quite abstract and theoretical as such. That's why I see in these two bodies of knowledge.
Sorry, not necessarily, Prof. You see, in the Omani Fiqh encyclopedias, they would sometimes name places because this is where the cases happened, right? Yeah. Somebody coming from Basra wanting to go to Sri Lanka, and then he changed his mind. This is because this is what happened. But generally, they discuss these cases as Islamic masail, as legal cases. And then for the Malaysian codifications, now, yes, it is abstract. It is a codification of law, but we also know that approximately where it has been implemented, right? Because we know approximately where was the authority of the Sultanate of Melaka, which proxies did the Sultanate of Melaka have in the Malay archipelago. And then there's also historical evidence on the different sultanates that took over this law, right? So the codifications, I came across this. I think I deleted it from the slides, but it will be in the paper, inshallah, where there is a reference even to Makassar, the Makassar law code, and it may have been, derived from the Malaccan code. Maybe also they had another common source. We don't really know, right? But as you said, it needs a historian to delve more into the details of this.
Yeah, right.
Assalamu alaikum warahmatullahi wabarakatuh. Sister, how are you? Didn't see you for a long time after you.
Alaikum salam. I have no idea who's talking to me now.
I'm Prof here.
Oh, mashallah.
Formerly, I was Dean for Faculty of Economics there.
Yeah, I remember.
And then what adds to my understanding, something before the history of the Oman. And because as you know, the common knowledge and understanding, your technical part later on, your lecture, actually, I didn't follow because that's too technical for me to have to legal discourse because that's not my background. But historically that, you know, these people from Oman, they are practicing neither Shafi nor Hanbali, they have the Ibadi movements. And this Ibadi movements actually originates from the time of the Osman radiallahu ta'ala anhu, when this problem arises and the qisas were being demanded. And so they are originally all from Najd. But what happened when the crisis took place during the time of the Osman Ghani radiallahu anhu, the issue was that from Medina, they came to collect taxes and zakat from the people of this Najd. And then they rebel against the Osman radiallahu anhu. There's no rain, there is nothing. And when we got some food grains, now you have come to collect the zakat. That's what the foundation is started. That's why this Khawarij, they were expelled after Osman radiallahu ta'ala anhu was martyred. And they run away to east for safety.
I'm
Because
sorry
of
for
that's where
interrupting.
they end up into Oman. And that's why they are all called Khawarij.
I'm sorry, I can't agree to this, neither from the historical point of view,
I'm
from the
talking
historical
about
sources point of
Qasim
view.
itself. I'm talking about those people who got relatives in Oman. They are the one who has shared this story, that these Khawarij are basically so neither they go into Sunni, neither they go to Shia. So they are somewhere between. Ibadi movement is started and they got their own madhab and everything. So perhaps they may have some benefits of it because they are not into the two mainstream Muslim societies. And they have been geographically located at such a place in the Arab and Indian Ocean that you cannot bypass them. But in our part of the world, Malaysia, we have more Yemeni descendants from Yemen, Aden, rather than from the Sohar and other areas. My mistake, then I checked with the Tomura, they said, no, that's not the case. I thought you were talking about Malabar, which is the South India, where they would have stopped it, Then
Prof, I'm sorry, can I just say something here?
No, let me finish. And later part, even the Kedah, I think is before Melaka Sultanate, is a Kedah very disputed history. The Penang today partly have been the part of Kedah. So I wouldn't know what were the Undang-Undang then in Kedah. Certain South Thailand provinces, 5 of them, the original Kedah. So these are all the historical twists, but I don't think that is the focus of your research. Your focus of research is more on the marine law. And territorial boundaries usually make the difference. So perhaps I think I need to be made more understand clearly because you have totally ignored the Indian roots, even though Indian Ocean have been the major roots of the trading before coming to Melaka and coming to Kedah. So these are a couple, not question, actually just observation. Maybe you can have.
Yeah, but I need to say something about these observations now, Prof. So actually, I'm sorry to say that you opened Pandora's box, and I will need to answer some of those issues now. Now, first of all, of course, my paper here was not on the development or the history or the content of the Ibadi school. It was a comparison between the Omani Fiqh Encyclopedias, which happen to be pertaining to the Ibadi school, and the maritime laws that are to be found in there, and the codifications that you can find in the 15th century in Melaka. Okay, so this for one. So I did not ignore anything, Prof. As you choose to say, I ignored India. I did not ignore India. It was not part of my topic. So definitely India has a large role to play in there as well. And I mentioned in the end, maybe you have heard it, that I chose those two dots to connect. But of course, there were many, many other dots on the line because the trade routes spanned, of course, from Basra to Persia, to Oman, to India, to Africa, to the Malay archipelago, and up to China. So you can choose any one of these dots on the line and try and connect them. Now, because I did my research on the Omani Fiqh Encyclopedias, this is where I started. And when during my research, I found the Melakan compilation and codification, I thought, okay, this would be really interesting to compare. And this is what I did. So I'm sorry, no ignoring of any contribution that has ever been made anywhere else. Just that you need to confine yourself to certain topics that you know.
I understand you.
This is one. Second, I'm sorry, I'm not finished. Second, talking about opening Pandora's box, Prof. I would be happy if you wanted to invite me to give a lecture on the history of the Ibadi school. I'd be happy to do that. I'm not pertaining to the Ibadi school. I'm Sunni. I'm Muslim, alhamdulillah, right? But during my research on the Ibadi school, I can tell you that a lot of the ideas that are floating around on the school, on the origins of the school, do not have any foundation in the historical sources, neither in those of the Ibadi side nor in those of the other side. So the pieces you put together, Prof, also there's a lot of discussion on that. When you say that, yes, correct. After the issue of Othman and the clash between Othman and Ali and Muawiyah, that's the most important point actually in early Islamic history. Yes, different movements came about, okay? Now, very often the Ibadi school is associated with the Khawarij, but they are not Khawarij. And actually they distance themselves through their speakers. I just mentioned Abdullah ibn Ibad, who then the school is named after. They distance themselves from the Khawarij. Okay, there are letters preserved, communication between Abdullah ibn Ibad and between the leaders of the Khawarij, telling them that we have nothing to do with you, right? So the Ibadi school, as I said, is an Islamic madhab in its own right. It is in its fiqh more similar to the Sunnah schools than to anything else. So if you read the fiqh books, you won't find many differences between the Hanafi and the other books. And when you talk about Usul ad-Din, then maybe it is more similar to the Zaidi school. It is a school in its own right, just like many other schools came to exist in the time. Okay, the connection between the Ibadi school and, you see, nobody asked me to defend the school. I don't have to, but just because you mentioned it. The connection between Oman and the Ibadi school is through persons, yes, correct, and also due to the geographical, the topography of the place of Oman. So the movement actually started in Basra, in Iraq. And there were some of the tabi'in who hailed from Oman. Correct, they were involved. I mentioned Jabir ibn Zayd. Jabir ibn Zayd, he went to Medina and studied with Aisha, radiallahu anha. He took his knowledge from Aisha. He's a tabi'i, right? And he is original from Oman. So there were different places that, advocates of the school or followers of the school at the time went to because they wanted to establish their own political entity. That's another story, needs another topic for a lecture, right? But they went to Oman, they went to other places. They also went to Yemen. They also went to North Africa. Maybe you heard about the Rustamid state. Sultanate state was in its origin an Ibadi-led state. Okay, so it's not a couple of, or an issue of a couple of people who ran off from places to places. That's not a historical description. And I would implore you to just, go back to the sources, or give somebody the chance to hold a lecture on the origins.
I got in
Somebody who's more knowledgeable than I am.
Both in yes,
has a reason
students and Omani students. When the Saudi somehow happen to lead the Salat, Omanis don't mind, they will follow them. And if so happen otherwise, if any Omani starts leading the Salat, all the Saudis run away from behind. Because they say these are the people who are following the Ibadi, and neither they are Sunni nor they are Shia. Anyway, that's not the matter of a discourse. Basically, the one you rightly mentioned is the dot that has collected. We have the historical problem in Malaysia, how the Islam came to Malaysia. Some say the Arab sailors, they brought the Islam when they were traders. And some people say India was the one origin of the Islam to Malaysia, not the. So this is always disputes. And the fact is, if you put both together, they were the Arabs who came from Arab world, and they stopped in north, in the South India, Kerala and etc. And then from there, they continue the journey back to this part of the Malay archipelago. So both you put together, then it becomes the right perspective. Otherwise, you put separately.
Actually, it wasn't a one-way development. Now, when we talk about trade routes, there were many people involved in this. Islam spread along the Indian Ocean littoral, right? So of course it spread in India, South India, Kerala. They heard of Islam in the time of the Prophet, alayhi salatu wasalam. We know that people in Kerala became Muslim in the time of the Prophet. Okay, so of course it plays a big role. But maybe you remember that I mentioned that in Melaka, they had influx from Arabs, Persians, Indians, people from Southeast Asia, and they named the different ethnic groups. So it's not like there was a flow from one direction only. No, there were many ethnicities involved. And what brought these ethnicities together, Prof, was Islam. And you mentioned the Yemenis and the Yemeni origins. Yes, of course. There was a lot of Yemeni influx, along with also Omani influx. So it's not only one part of the world that influenced everybody else. No, there was influx from Iraq. There was influx from Persia. Okay? And they all played their role, because in the end, Islam did not distinguish.
Yes.
This is the place was it really Penang? Was it Kedah, or the part which has gone?
I think it's Kedah. I mean Calabar. It's the Kedah area.
Yeah, but where?
Well, I don't know, but based on what I gathered, it would be the ports along the Kedah coast, one which is Kuala Bahan, which is now Kuala Kedah. Yeah, in the 1500, from the 1500. Yeah.
It's talking about
No. Of course, Malabar is instrumental. Yeah, and of course the coming of Islam to the Malay archipelago is still being discussed and debated. It's not only Melaka, but Kedah and Aceh and Pasai, and it's the whole geography. There's one question from a participant. The question is on piracy. Have you found rules on piracy around Melaka in the codes? Many.
Around Melaka, no. So for the Undang-Undang Laut Melaka, for the moment, I don't remember. But I found a lot on piracy, maritime piracy, in the Omani Fiqh books. And I have a published research on that, by the way, but it's published in Arabic in Majalat al-Tajdid, I think 2021. Oman wal Qarsan al-Bahriya. I published that with a colleague of mine, Dr. Said Sawafi. So there's a lot you can find on maritime piracy. Yes.
Is the definition of piracy in the fiqh similar to our conventional definition of piracy?
You see, they did not use the term qarsana in the fiqh books, which is the modern term, but they made an analogy to you know, I don't know how it's called in English now. Qati al-tariq, al-hiraba. Sorry, I don't get the term right now. I don't remember the term right now. So there's a whole lot on that. So I just recommend, because that would be a lecture in itself, Prof. Happy to do it. But I recommend that maybe whoever asked that question can go back to the published research that I have on heresy. So if you Google my name, you'll find it.
The Arabic or English?
Sorry?
In Arabic or in English?
That one on heresy is in Arabic, but I have a paper in English on the territorial sea and Harim al-Bahar. That one is in English, published in Majallat in the Ilahiyat journal Ilahiyat journal in Turkey. Easy to find. It's online.
Google your name and now we can learn much more. Just before we end, there's one thing you mentioned about the Shahbandars in Melaka. I think the Khojas or the Khwajas would represent the Persian-speaking Shahbandars. But we're talking about the absence. But I think but they came from the Persian-speaking part of India, I mean, basically Gujarat. So I think they will represent that Persian community, Persian-speaking community. They were thinking about what, maybe Shahbandars from different ethnic groups, Arab, Persian, Chinese, and I think Javanese. I'm not too sure, but that's what I gathered. So in other words, there would be some rules on this appointment.
Definitely. You see, the information on the Shahbandars and the different communities. I think the book of Yusuf Hashim, the Melaka Sultanate, is quite a good source on that.
Yes.
Or else the contributions of Peter Borschberg. He has a lot on that as well. But I don't remember I found any Shahbandar for an Arab community.
Yeah, also
Hashim mentions Yusuf Hashim mentions the different communities, but I don't remember them now.
Yeah.
And the term Shahbandar, of course, Shahbandar is a Persian term, and probably it came there either from Persia or via India. Yeah, we don't know.
But when you ask a Persian, they'll say, yeah, it comes from Persia. So again, when referring to the spread of Islam, when you ask some Iranians here, they will say, yeah, they were the ones who were instrumental in bringing Islam to this part of the world. Anyway, we'll have to end this useful and interesting session. And your paper would be a valuable contribution actually to the discourse over the 15 lectures that we had. Earlier lectures would speak about the conceptual aspects of civilization, and then we have papers on Melaka, also on Kedah. We have papers on early settlements in Terengganu, and also on the formation and forging of identities as a result of these movements of people in the Malay archipelago. And your paper would perhaps bridge that gap. Again, as I mentioned earlier, this discourse crossing national boundaries. I think state-centric discourses may not do justice to what has happened, and may not do justice to what we should know about ourselves, and in trying to make sense of the idea land and water as in the Malay archipelago. With that, we look forward to your paper. I'll update you.
Okay.
I hope to come up with a fair manuscript. I'm chasing after the other speakers as well. I hope to get about 16 chapters,
Okay.
including mine, and 17. Yeah, there's after yours there'll be another speaker, and the last speaker will be myself. Probably end of the year or early next year. So the idea is to have well, perhaps a 16-month lecture, but it has stretched over the year, over the months, because of many university obligations that we need to do, and so we need to spread out. So thank you very much, Professor Bouzenita.
You're most welcome. And again, thank you so much for having me.
Yeah, we'll get it back to you. Salam
Okay, fine. Alaikum salam wa rahmatullah. Thank you.